Hi, I'm Kate Floss, as you all know, and today I'm going to be talking about the different sets of rights that we have around the world. Unfortunately, all of us in the Commonwealth countries, especially New Zealand, Australia and England, have been led to believe that our indubitable rights are no longer with us, and we've been led to believe that we should all be using some other type of rights. Today I want to explain to you what each of the types of rights are, where they come from and how they can be useful for you. One of our problems in the Commonwealth at the moment is why do we seem to have no power? It's because you are all using the wrong rights and you're not using your ancient rights that have been promised to you for centuries. So I'm going to explain the different types of rights today. As everybody knows, and what each one of them means, as everybody knows that the 1688 Bill of Rights, the 1688 Bill of Rights are called indubitable rights. They're not called inalienable rights. And they're not called unalienable rights. They're called indubitable rights, and I'm going to explain what that means, but keep that word in mind because it has meaning and it is significant. The next set of rights we have are the Declaration of Independence. Now, this is for America, and in America they have got inalienable rights. You might want to wonder why they have inalienable rights and why we have indubitable rights, which are very different. Well, theirs came from, I'll just go into a little bit of my very limited knowledge of history. When Britain was in America trying to negotiate a treaty with the Indians, to my limited understanding, the people that had lived there for 100 years or more, who became Americans, they started to fight against the British and they wanted the British out. And what had happened was the American Indians owned all of America. It belongs to them. They are the allodial land holders, the allodial title holders. But for the American people to take over the country, to my understanding, they basically had no rights because the American Indians didn't have a government. So the Americans gave themselves this Declaration of Independence, and they called their rights inalienable, which means it permitted them as aliens to have rights in a country that didn't belong to them. Now, New Zealand, Australia and England, Scotland and Ireland, we are very different because and even Canada, because we are Commonwealth, all the Commonwealth countries all negotiated with England and they all agreed to put their allodial lands into the hands of the Majesty to take care of and to protect our countries. And we were all given indubitable rights because the people on the Commonwealth country lands had not had their lands invaded. They had gotten their protections through a treaty. So these two rights are very, very different. The next one we've got in New Zealand, just introduced in the last 30 years into New Zealand, Australia, England, Scotland, is the 1990 Bill of Rights. Now, the 1990 Bill of Rights applies to subordinate acts, acts that are made outside of the indubitable rights or even the inalienable rights. And what these acts do to put our rights into laws and to make sure that they're incorporated into laws. But whenever they do this 1990 Bill of Rights in our countries, it is actually enabling this thing here called humans rights. Now, humans rights are for workers and immigrants. They are immigrants' rights because None of these people are able to swear allegiance to the majesty. They see it as being against God. And so they come under another set of rights called the who man's rights, and they're trying to tell you that you all belong in these rights, but you actually don't. Now, who does the who man's rights belong? So inalienable belongs to all of the countries that were independent of the Commonwealth, but where they had invading forces on the natives that were living there that owned the lands. So, but the who man's rights is different, and it belongs to a thing called, Australia will have theirs, England will have theirs, the New Zealand Society of Actuaries Incorporated. And then you have to ask yourself, what is an actuary? An actuary is a business professional who deals with the measurement and the management of risk and uncertainty. So what they do, what is their job for the who man's rights? Their job is to look at our indubitable rights, then they look at the inalienable rights, and then they look at the Bill of Rights, the 1990 Bill of Rights, which is the buffer between these, and then they look at the risk management. Now, I'm going to explain to you why they have to do the risk management in a minute. So first of all, we're going to look at this Declaration of Independence from America. Now, this is their definition of an alien. An alien is an individual who does not have US citizenship and is not a US national. The INA, whoever that is, defines a national of the United States as one who, while not a citizen, owes permanent allegiance to the United States. In actual fact, all Americans are aliens to the country, to be honest. I'm sorry to tell you that. Which is different. They keep trying to pair them up with our New Zealand Maori and our Australian Aboriginals, but we've got different treaties to what they never made a treaty. This is the difference. They really did invade. And they didn't make a treaty. All they made was a Declaration of Independence for themselves. To my knowledge, all the Americans are going to come out with their claws on me over this one. The alien in national and international law is a foreign-born resident who is not a citizen by virtue of parentage or by naturalization, and who is still a citizen or a subject of another country. Now, I want you to remember this alien, because we are not aliens in New Zealand and Australia and Scotland Island, or the Commonwealth. We're not aliens. We are subjects. So there's the difference. The independent countries are all aliens, and the Commonwealth countries are all subjects, and we all come under subjects. What does inalienable mean? It means unable to be taken away from or unable to be given away by the possessor. And one of their inalienable rights is freedom of religion. Now, freedom of religion is repugnant to the 1688 Bill of Rights because ours is a protection for Protestant people. Why is there no freedom of religion? You'll notice that many of the Zionist religions go and live in America, and this is because they have the freedom of religion. Now, I'm not saying their religion is bad, but they have some practices that are repugnant to our Commonwealth rights. One of the practices is that they not only do they circumcise the baby's penis, but some of them also suck the blood of the baby's penis after it's been circumcised. Now, apparently, if you belong to a religion, that is perfectly fine. And apparently, if you don't belong to a religion, that is called pedophilia, apparently. Now, the Jewish religion, and correct me if I'm wrong, I'm just stating the facts, I'm not anti-Semitic. If this is what you want to do, I'm not doing it. But apparently their children are born to the religion, and if they try to leave the religion, they're either not allowed to take their children, their grandchildren with them, or the mothers are not allowed to take their children with them away from the religion. And I'm told that also leaving the religion can also result in death. And this is the same for the Islamic religion. They also have many, many laws regarding marriage of 60-year-old men to 5-year-old children. So all of these laws are repugnant. And so this is why we don't have freedom of religion in our countries. So the inalienable rights has freedom of religion. And so we have the 1990 Bill of Rights as the buffer, and then those actuaries that I was talking about, those actuaries check if their religious freedoms are repugnant to our 1688 protections of Protestants. And they do the risk management of what can be blocked, but without taking away their free opportunities to practice their religion. So some things would not be allowed and some things would be allowed in our countries, but they have their countries that allow all of these things. Now the American Constitution I'm just to tell you a wee bit. People are asking what is the difference between inalienable and unalienable. And apparently the only difference is that in the American Constitution it uses unalienable. And they reckon that they've changed it to inalienable. But here's what it says. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, which means that no alien can come in and take away these rights. That among these are life, liberty, and pursuit of happiness. And apparently big on the American Constitution is the freedom of religion, which is repugnant to some of our Protestant rights. So the American Constitution is so far off our 1688 Bill of Rights. They are like black and white. They're not the same. So what we've got a lot of Americans in New Zealand and Australia tramping around telling people, why not use this American Constitution? Well, because it's repugnant to Protestant laws, in our God's laws. And so this is what they're saying about the difference there. Here's part of the American Constitution. I've not read all of it, but I've started reading it. That all men are created equal. Now, in the 1688 Bill of Rights, it explains to us why the king that was there was removed and all the things that he was doing, like decapitating people, cruel punishments, all in the name of their religions, stopping people from speaking. Well, the American Constitution also lists why they threw England out. And here's what it says. He, meaning the English king, has forbidden his governors to pass laws of immediate and pressing importance, unless suspended in their operation till his assent should be obtained. Now, this is where I'm going to tell you how New Zealand, Maori and Australian Aboriginals and all of the natives from the Commonwealth countries are very different from the American Indians, because it says it right here. The king was waiting for assent from the natives to allow Britain to come in and establish laws. And Britain refused to enter the country completely until they got the assent from the people that they would be allowed to go in there and govern. Now, this assent was given in New Zealand, it was given in Australia, and it was given in all Commonwealth countries by treaties and various things with the chiefs. So this is why America is not inside the Commonwealth. The Commonwealth is not the same, and we run on different laws from independent countries. It says he, meaning the king, I assume, has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in legislature. Now, I'm not quite sure about that, but I'm assuming that these large districts of people are large districts of Anglo people, and they wanted to have a certain amount of power in the legislative, which I think what they wanted to have was power that was not voted in. The 1688 Bill of Rights, everybody has to be voted in, and the religious leaders are not there. Lord's spiritual and Lord's temporal are outside, and then Lord's Commons, which is us, are in the Parliament. And they wanted certain people, I think, to be guaranteed their place in the legislature. So that would have been very different from English Parliament. And so this is why they threw the British out. Now we're going to go to our 1688 Bill of Rights. So our 1688 Bill of Rights are called indubitable. And we want to go and have a look at what this means, indubitable. So we looked up dubit, I say, but indubitable and becomes dubit. And it is a verb, and what it means is to be uncertain about, to consider something questionable or unlikely, and to hesitate to believe its basis. And it's talking about to believe its basis in law. Now, the noun is a feeling of uncertainty about the truth, the reality, or the nature of something, or to the natural law, because all laws must be based on the natural law. And if it's going outside of natural law, then it's considered to be dubious and questionable. Now, whenever you type in dubit, you're going to come up with dubitant. And dubitant in Latin means to doubt. Now, this is used in law of a judge who is doubtful about a legal proposition, but he hesitates to declare it wrong. So what this means is when they create an act, and if somebody goes and asks the court for a declaration of their indubitable rights and says to the judge that this act is repugnant to my indubitable rights, the judge doesn't need to say who is right or who is wrong. He only needs to make a declaration to say that he is doubtful that the law that was created comes under the natural law. And then that law will usually need to be removed, especially if it seriously damages our rights. Some judges use this term after their names in separate opinions, as if analogous to concurring or dissenting. Doing so may signal that the judge has doubts about the soundness of the majority opinion. Now, this comes of when a law gets made in Parliament, 75% of Parliament have to vote for it. And so if you look in our countries at the moment, we've got two major parties that are ruling the roost. And when those two major parties, like in America, get together and make agreements on laws, it's very easy to pass a 75% opinion. And this is where we, the people, have got to look at this opinion and send it to the judge and ask for a declaration if it's against any of our rights, and ask for a declaration to show that he is doubtful, or it has a indubitante against this law. And that way, the judge can override laws that have been made in Parliament. Okay? So the definition of indubitable is unquestionable. It is too evident to be doubted that there's something. And then what happens is, if you look at the 1688 Bill of Rights, you'll see a list of about 10 or 12 rights is what you'll see. And then if you see that any of these rights have been infringed upon, you go to the judge, and this says the subject's liberties to be allowed. And you'll see here, these are, the judge will make a declaration. I'm going to show you an example. The judge will make a declaration that they are true and ancient and indubitable rights, which means these rights are unquestionable. You cannot question any of the rights in this document. And he says, and the liberties of the people of this kingdom, and this is what he says. He will make a declaration, and I'll show you an example in a minute. He will say, and so this right shall be esteemed, this right shall be allowed, it shall be adjudged, and it shall be deemed and taken to be. There's the order. There's going to be, if you go to the judge, what there's going to be is a declaration that your right is true, and then he's going to say that it is deemed and taken to be, especially deemed and taken to be. Usually he short writes it to be deemed and taken to be. And then he makes the order as they are expressed in this declaration. They are to be firmly and strictly held and observed. And that all the ministers, all officers and all ministers whatsoever within the Commonwealth must obey this order. So that you're seeing around the world that these ministers are being taken out in certain countries, it's because these freedom fighters or whatever, they're lying to you. What they're doing is they're using these indubitable rights, and they're going to the courts and they're asking for the declarations, and this is what we need to do. Now this here, indubitable rights, overrides the Human's rights, it overrides UN law, it overrides the United States Constitution, and it overrides all Bills of Rights, 1990 Bill of Rights in New Zealand and Australia and England. And what they're trying to do in our Commonwealth countries is to make, see, these laws here are entrenched, which means they can't be removed. But what they're trying to do is to make the other Bill of Rights to be the supreme law. This here is called, these laws here are called the supremacy laws, and they're trying to make the new one the supreme laws. Now, here is an example. In 1865, the New Zealand Maori people, they were fighting for their land, and in the 1688 Bill of Rights is one right called grants of forfeiture. And what was happening was that the council officers and ministers were granting forfeitures of land for no reason, with no trial, to the New Zealand Maori people. The New Zealand Maori people, and then when the New Zealand Maori people started calling out their rights, they were told that they did not come under the 1688 Bill of Rights because they were not subjects. However, in the Treaty of Waitangi, they were made subjects, and the New Zealand Maori went to the court and they asked the judge for a declaration. And when they made the declaration, you'll see here this indubitable right being ordered by the judge. The judge says every person of the Maori race within the colony of New Zealand, whether born before or since New Zealand became a dependency of Great Britain, shall be, here you see it here, shall be taken and deemed to be a natural born subject of Her Majesty to all intents of purpose. So this is what we've got to do in all of our countries. You've got to go to the court, and we're doing this now in New Zealand. You've got to go to court and ask the judge to make a declaration that you continue to be subjects of the Commonwealth under Her Majesty. Once you get that declaration, you can then take that declaration and file cases where your rights have been infringed upon. So, and then this was about land, but it can be about anything. The Supreme Court, and he's ordered the Supreme Court and all other courts of law within the colony ought to have the same jurisdiction in all cases. So he's saying they're all going to be equal as everybody else, touching the persons of the property, whether real or personal. So this is just not about land of the Maori people and touching the titles to lands held under Maori custom or usage. And so this is the declaration, but the place where any judge, when you take this declaration to any court of law or any police officer, the first thing they're going to see is be taken and deemed to be. And this is the order. And then as soon as they see that, it says in there that all ministers must obey. And so here is another example. In this case, it might be quite hard for you to see. So I'm hoping that you're going to be able to see. But it says in this declaration, there was some question about the law. And what they said was that the New Zealand Maori, in February 1840, they declared themselves as subjects. And there were people who had bought thousands of acres of land before the New Zealand Maori became subjects. And then these people were fighting to retain their land that the Majesty was going to take back and look at all their land deeds and confiscate lands that were taken illegally. And what the New Zealand Maori went to court again using the 1688 to ask for a declaration that the laws of England, here's something interesting, I don't know if you'll be able to see it. It says that an act to declare that the laws of England, so far as applicable to the circumstances of the colony, to have been in force thereon and after the 14th day of January 1840. So the treaty making themselves subjects was only signed in February, but in fact, New Zealand came under British law fully and completely and legally from the 14th day of January 1840, long before the Maori version of the treaty was signed. And I'm saying that the treaty, the English version, was already signed, sealed and delivered in New South Wales before the Maori version of the treaty was ever signed in February of 1840. And British law came to be in New Zealand on the 14th day of January of 1840. And this was another declaration. I don't know if you can see it, but it says here the same. You're going to get the same just down here. it says be deemed and taken to have been enforced. As soon as the judge orders that it is deemed and taken to be, this forces all ministers, all prime ministers to kneel to the majesty. You have got to force them to kneel. And this is what you're not doing, because you're using inalienable rights. And we in the Commonwealth, we don't use inalienable rights. We have treaties with our native people, and our native people have treaties with us, and we use indubitable rights. So we can go to the court and we can get our declarations. Now, this was just the example of the first one that I read to you, and how the New Zealand Maori used it. Here is a strange example over here. This is where, previous to the 1688 declaration, I don't know if you're going to be able to see this, but I hope you can, but previous to the 1688 Bill of Rights, these people went to court and asked for a declaration. And did you know that the S used to be an F? I'll try and read a bit of it. I'll come over here, you won't be able to see me, but I'll try and read it. It says, be moved with the duty and obedience which by the laws your petitioners owe unto your sacred majesty. They used F. They humbly present, which is present, unto your princely and pious wisdom, which is wisdom, the federal pressing grievances following, which is the several pressing grievances. So we used to use an F in the place of S. The pressing and unusual impositions upon merchants. So it says the pressing, I'll have to change the F for an S so you understand. The pressing and unusual impositions upon merchandise importing and exporting. Now this was the Catholics as they had with the missionaries in 1835. The merchant ships and goods have been taken and destroyed both by the Turkish and other pirates, and the multitude of monopolies, patents and warrants whereby in the trade city and other parts of the kingdom is much decayed. Now, the New Zealand Maori, this is the example. Everything that these missionaries did to the New Zealand Maori, they already did it in England. They took over all the ports, and it says the sundry innovations in the matter of the religion. This was the Jewish religion and the Catholic religion and the Islamic religions were taking over all the ports in all the countries all around the world. That's what they were doing. And we Protestants had to stop them. And let me tell you something. They're back. They're in our countries now with their human rights. And here the complaint is the oath and canons, meaning the Catholics, lately enjoined by the late convocation, whereby your petitioners are in danger to be deprived of their ministers. It means that their ministers were going to be usurped and thrown out because the Catholics and the Jewish leaders and the Islamic leaders were in the country taking it over. They'd already taken over the ports, they were taking over the ships, and they were starting to take over in the parliaments. So we had to create a law called the 1688 Bill of Rights that said no religious leaders or religions can govern over us, one, and two, foreigners could not work in our parliaments because they take us over, and that's what they're doing now. So this is a clear example of the declarations. I'm going to read it. Now, the last one we get to is the 1990 Bill of Rights, which Australia's got the 2017 Bill of Rights, and England's got, they've got a new Bill of Rights as well. And they're trying to get us to follow it. Don't follow it. Use your indubitable. Now, they've got a thing in that Bill of Rights called justified limitations, and they're trying to get rid of this law, but we need it because this is, and this right here is to affirm, protect, and promote the humans' rights, who are the humans' rights? It belongs to the actuaries that weigh up the risk of the religious people coming into our countries and how many blocks are needed against them through this justified limitations so that they can't use parts of their religion, such as decapitating us, in our countries. So that's why we've got this buffer in between, all right? Now, so the 1990 protects their humans' rights, and the indubitable rights of ours protects our rights in commonwealth countries. And then the American Constitution, they have their inalienable rights that are a little bit different also from humans' rights. So many different kinds of rights. You all have to understand, or you all need to know where you need to be standing. Where is your solid ground? And this is the 1990 Bill of Rights is to affirm New Zealand's commitment to the International Covenant on Political Rights of other religious leaders. But we better be careful with that one, I'm telling you. Now, if you go to the 1990 Bill of Rights, you will go right down to the bottom. Go right down to the bottom and you're going to see Article 28 and read what it says. Article 28 of the 1990 Bill of Rights says, other rights and freedoms are not effective. And what are the other rights and freedoms that they're talking about? They're talking about our indubitable rights. So any laws that they make using the 1990 Bill of Rights or the Health Act or the Humans Rights, any laws that they make, if it is repugnant to our indubitable rights, we can go and use Section 28 and we can take this to the court together with our complaint of the right, indubitable right that they are affecting, and we can ask the judge for a declaration. The judge, in his wisdom, will, if we are correct, he will make a declaration to tell all of the ministers to kneel. You've got to force them to kneel to the Majesty. Now, they are of the opinion in Parliament that if they don't swear allegiance to the Queen, that they don't have to follow these rights. But actually, they still have to, because if they don't, they'll need to leave Parliament because these rights belong to us. They can't take them. And it says here, an existing right, which is your indubitable right or freedom, shall not be held to be abrogated or restricted by reason only that the right or freedom is not included in this Bill of Rights. For example, in the indubitable rights, Protestants have the right to have a weapon. In the Humans Rights, they don't have that right because their religions say that they can use it to kill people. But our religion don't say that. So there's no law in our Protestant religion that says, hey, if that person is not a Protestant, you have the right to go and kill them. Whereas their religion says, if any other person that is not of this religion says anything against this religion, you have the right to decapitate them or kill them. So that's all in their laws. But we don't have that law. So we have a law that we have the right to have a weapon to protect ourselves against them, actually. So, so that is, Section 28 is in your 1990 Bill of Rights, which is for them, and then you can use that. The Human Rights Act is the other one, and this is who the Human Rights Act is for. It's not for Commonwealth people. If you're in a Commonwealth country, the Human Rights Act is not for you. It's for immigrants, and it's for refugees, and it's for people that come to New Zealand that can't use indubitable rights, even though they're available to them if they want to. But they don't feel that they can swear allegiance to the Queen. So, therefore, they are not able to use it, but it's there if they want it. It's up to them to choose. But, and it says here, the Human Rights is for a person who is a fellow of the New Zealand Society of Actuaries Incorporated. Here's your corporation here, all right? So that is different from our indubitable rights. And so these are laws that are allowing the corporation to come into your country. If you want them out of your country, you've got to use your indubitable laws, and that will get them out. But you're not using them, and that's why you're all having so much trouble. And then I went to look at what is the meaning of an actuary. An actuary incorporated. An actuary is a business professional who deals with the measurement and management of risk and uncertainty. And so they look at the inalienable rights. When people want to come into Commonwealth countries, they look at the inalienable rights. They look at the freedom of religion. They look at the rights that which religion has. Islamic has some rights that are not healthy for us. Jewish have some rights that are not healthy for us. They look at those laws and they put a blocker on the ones that can hurt us, and they use their risk management to decide, is this something that's going to hurt people, or is this something that's going to benefit them to be able to exercise their religion and continue to have their religion. And that's why they weigh all these things up. And so they can't just go along and say, all right, we're going to take this religious right away from you just because you're Islamic. They can't do that. But they can look at, they can say, hey, there's a decapitation law. They can look at our indubitable law and they can see that that would come under cruel and unusual punishment, and they can say, well, no, you can't have that right in our Commonwealth country. But then they'll look at another one that says, okay, they have the right to have a little place that they can pray 5 times a day. They'll go and look at our indubitable rights. They're looking at, is that against any of those rights? And they can say, no, it's not going to hurt anybody. So they can say, yes, you can have that right. So that is what these actuaries do. And so that is the Human Rights. 1990 is the blocker and the buffer, and they recheck it. And then if that right's all right, then that can be put into our country. But whenever you're in the Commonwealth, always remember. So always remember the Commonwealth forever, 1688 Bill of Rights, so help me God. Use your indubitable rights. You are not, if you're in the Commonwealth, you are not under inalienable rights. You are not under Human Rights. You're not even under the 1990 Bill of Rights. What you come under, or what you are protected by, is your 1688 indubitable rights. And if any of your indubitable rights have been infringed upon, you may rightfully go directly to the High Court, ask for a declaration, and then when you get that declaration, you then go and present that to the police or the minister or whoever it is that is annoying you. So you've got to do it. Now, I'm just want to remind you that I'm Kate Floss, and I've presently got one case sent to the court, and I've got another case that has been sent to the court, and unfortunately I have to pay for these cases myself. Me and Curry's working for free. Curry is the one that is doing all the legal bit for me, but I'm the one that's going to fight the case. And the first declaration that we're going to be asking at the court is to, just like the New Zealand Maori did in 1865, I've learned from them, is to go and ask the court to make a declaration that our indubitable rights are intact and we continue to have them. And then the second case that we're going to be taking to the court is that the electoral law was changed to allow foreigners to be in our parliament. Now, this is repugnant to our 1688 Bill of Rights under the supremacy law that forbids foreigners to govern over us in our parliament. Now, it costs me, from my own money, $540 to send one of these cases. I'm paying for it for my own money, but if you can find it from the kindness of your heart, to put a little bit, if you've got $5 or you've got $10, everything will help. Put a little bit in there for me and Curry so that we can get these cases into the court. We don't know, we can't promise you that we're going to win. We can't promise that, but what we can say to you is that at least for the first time in 2 years, our voice is going to be heard in the court. I'm going to make a statement in the court, and if any of you have got any messages that you want me to say to the judge, I'm going to be able to do that, I think, in my statement when we call Jacinda Ardern and Chris Farfoy to the court. I'm going to be able to make a statement. So if there's anything that you want to tell them, any rights that you think have been impinged upon, you can send that to me, and I will make a note of it and put it in the statement when we go to the court. At least we don't know if we're going to get anywhere. There's no promises. But we will, for the first time, be able to get our voices heard in a court of law. And I think it's better than nothing. So God bless everybody. God save the Queen. So help me God. And hang on to your indubitable rights.